This is going to be 10 minutes at 220 words a minute jury charge for endurance and strength and all that fun stuff. 10 minutes, ready. Members of the jury, now that you have heard all of the evidence and the argument of counsel, it becomes my duty to give you instructions of the court concerning the law applicable to this case. It is your duty as jurors to follow the law as I shall state it to you, and to apply the law to the facts as you find them from the evidence in the case. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me. Regardless of any opinion you may have as to what the law is or ought to be, it would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would be a violation of your sworn duty as judges of the facts to base a verdict upon anything other than the evidence in this case. In deciding the facts of this case, you must not be swayed by bias or prejudice or favor as to any party. Our system of law does not permit jurors to be governed by prejudice or sympathy or public opinion. Both the parties and the public expect that you will carefully and impartially consider all of the evidence in the case, follow the law as stated by the court, and reach a just verdict regardless of the consequences. There are two types of evidence, direct and circumstantial. Direct evidence is the testimony of a person who claims to have personal knowledge of an event, such as an eyewitness. Circumstantial evidence is the proof of a chain of facts and circumstances that tend to show whether or not an asserted fact is true. The law makes no distinction between the weight to be given either direct or circumstantial evidence. Therefore, all of the evidence in the case, including the circumstantial evidence, should be considered by you in arriving at your verdict. Opening statements of counsel are for the purpose of acquainting you in advance with the facts counsel expect the evidence to show. Closing arguments of counsel are for the purpose of discussing the evidence. Opening statements, closing arguments, and statements by counsel between the witnesses' testimonies and any of the other statements of counsel should be disregarded to the extent that they are not supported by the evidence or are inconsistent with the law that I am giving you in these instructions. As I have mentioned, any statements, objections, or arguments made by the lawyers are not evidence in the case. The function of the lawyers is to point out those things that are most significant or most helpful to their respective sides of the case, and in so doing to call your attention to certain facts or inferences that might otherwise escape your notice. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in this case. What the lawyers say is not binding upon you. A stipulation is an agreed statement of facts between the parties, and you should regard agreed statements as true. So while you should consider only the evidence in the case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the testimony and evidence in the case. Inferences are deductions or conclusions which you draw from using your reason and common sense and the facts which have been established by the evidence in the case. In determining any fact in issue, you may consider the testimony of all witnesses, regardless of who may have called them, and all exhibits received in evidence, regardless of who may have produced them. You are not bound to decide any issue of fact in accordance with the testimony of any number of witnesses which does not produce in your minds belief in the likelihood of truth, as against the testimony of a lesser number of witnesses, or other evidence which does produce such belief in your minds. The testimony of a single witness which produces in your minds belief in the likelihood of truth is sufficient for the proof of any fact, and would justify a verdict in accordance with such testimony, even though a number of witnesses may have testified to the contrary, if after consideration of all of the evidence in the case you hold a greater belief in the accuracy and believability of the one witness. This test is not which side brings the greater number of witnesses or presents the greater quantity of evidence, but which witnesses and which evidence appeals to your minds as being most accurate and otherwise trustworthy. The law does not require any party to call as witnesses all persons who may have been present at the time or place involved in the case, or who may appear to have some knowledge of the matters in issue at this trial, nor does the law require any party to produce as exhibits all papers and things mentioned in the evidence in the case. You, as jurors, are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You may be guided by the appearance and conduct of the witness, or by the manner in which the witness testifies, or by the character of the testimony given, or by evidence to the contrary of the testimony given. You should carefully scrutinize all the testimony given, the circumstances under which each witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. Consider each witness's intelligence, motive, and state of mind, and demeanor and manner while on the stand. Consider the witness's ability to observe the matters as to which he or she has testified, and whether he or she impresses you as having an accurate recollection of these matters. Consider also any relation each witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause the jury to discredit such testimony. Two or more persons witnessing an incident or a transaction may see or hear it differently, and innocent misrecollection, like failure of recollection, is not an uncommon experience. In weighing the effect of a discrepancy, always consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or intentional falsehood. After making your own judgment, you will give the testimony of each witness such weight, if any, as you may think it deserves. You may, in short, accept or reject the testimony of any witness in whole or in part. A witness may be discredited or impeached by contradictory evidence, by showing that he or she testified falsely concerning a material matter, or by evidence that at some other time the witness has said or done something, or has failed to say or do something that is inconsistent with the witness's present testimony. If you believe that any witness has been so impeached, then it remains your exclusive province to give testimony of that witness such credibility or weight, if any, as you may think it deserves. When any witness is questioned about an earlier statement that he or she may have made or earlier testimony that he or she may have given, such questioning is permitted in order to aid you in evaluating the truth or accuracy of his or her testimony at the trial. In addition, if that earlier statement was made under oath and is inconsistent with the witness's testimony at the trial, you may consider that earlier sworn statement as evidence of the truth or accuracy of such earlier statement. Whether or not such prior statements of a witness are, in fact, consistent or inconsistent with his or her trial testimony is entirely for you to determine. The rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists as to those whom we call expert witnesses, witnesses who, by education and experience, have become expert in some art, science, profession, or calling, may state their opinion as to relevant and material matters in which they profess to be an expert, and may state their reasons for the opinion. However, the fact that an expert has given an opinion does not mean that it is binding upon you or that you are obligated to accept the expert's opinion as the facts. You should assess the weight to be given to the expert's opinion in light of all the evidence in the case. Certain charts and summaries have been shown to you in order to help explain the facts disclosed by the books, records, and other documents which are in evidence in the case. However, such charts or summaries are not in and of themselves evidence or proof of any facts. If such charts or summaries do not correctly reflect facts or figures shown by the evidence in the case, you should disregard them. In other words, such charts or summaries are used only as a matter of convenience. So if, and to the extent that you find they are not in truth summaries of facts or figures shown by the evidence in the case, you are to disregard them entirely. Each plaintiff has the burden of proof as to the damages he is claiming. When I say that a party has the burden of proof on any proposition, or use the expression preponderance of the evidence, or use the words if you find, or if you decide, or determine, I mean you must be persuaded, considering all of the evidence in the case, that the proposition on which the party has the burden of proof is more probably true than not true. The rule does not require proof to an absolute certainty, since proof to an absolute certainty is seldom possible in any case. Upon retiring to the jury room, you will select one of your number to act as your foreperson. The foreperson will preside over your deliberations and will be your spokesperson here in court. Official forms of special verdict have been prepared for your convenience. You will take these official forms to the jury room. You will note that the two separate verdict forms have been prepared for each plaintiff. Each question on each verdict form must be unanimous answered of the jury. Your foreperson will write the unanimous answer of the jury in the space provided opposite each question and will date and sign the special verdict forms. When completed, you will then return with the completed special verdict forms to the courtroom after first informing the marshal in charge of the jury that you have reached a verdict. Members of the jury, you are free to deliberate in any way you decide or select whomever you like as foreperson. However, I'm going to provide some general suggestions on the process to help you get started. When thinking about who should be the foreperson, you may want to consider the role that the foreperson usually plays. The foreperson, serving as the chairperson during deliberations, should ensure a complete discussion by all jurors who desire to speak before any vote. Each juror should have an opportunity to be heard on every issue and should be encouraged to participate. The foreperson should help facilitate the discussion and make sure everyone has an opportunity to say what they want to say. You may, if you find it necessary during your deliberations, submit written questions to me about the case, but you should understand that you, as the jury, must decide the facts. You should make a determined effort to answer any question by referring to the jury instructions before you submit a question to me. If you do submit a question, I must show it to the lawyers for each side and consult with them before responding. I will either answer your question or explain why I cannot answer your question. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement. If you can do so without surrendering your individual judgment, you must each decide the case for yourself, but only after an impartial consideration of the evidence in the case with your fellow jurors. That was 10 minutes exactly.